Today's video focuses on stormwater discharge and the legal implications, particularly with a focus on the law of private nuisance. Now, as always, quick disclaimer, please do not rely on this video as legal advice. Each circumstance is unique and you need to get independent legal advice specifically tailored to your unique situation. All right, with that out of the way, let's cover three broad principles that we can pull from the case law about stormwater discharge and the overland flows of water across land. The first of those principles is that, generally speaking, natural surface runoff across land is not actionable. So by natural surface runoff, what I mean is rain falling down onto existing ground level and naturally sheeting across the existing ground across land. So that's natural surface runoff. The second principle relates to watercourses. An owner of land upstream has a right to allow the watercourse, the natural watercourse, to run through their land and into the downstream property, and vice versa. The owner of the downstream property has an obligation to accept that watercourse, but also a right to receive that water coming from the upstream property. Australia is a very dry continent, and so there is a plethora of legislation dealing with water. I'm not going to go into that today, but generally the common law is as I've stated, and then it's overridden by specific legislation in states and also at the Commonwealth level. Finally, what I've said about natural surface runoff doesn't normally apply when that natural runoff is somehow captured or concentrated and discharged into neighbouring land. Typically, or generally speaking, the person doing the capturing and the discharging has the responsibility to deal with that water in a responsible way that doesn't materially impact with their neighbours' use of their land. All right, now I've used the word nuisance a couple of times in this. What is a nuisance? It's an odd phrase in law, but generally it means a material and an unreasonable use of your land that results in a material and unreasonable interference with your neighbour's enjoyment of their land. So there's a few things to unpack there. The first is that the thing complained of needs to be material, it can't be trivial. Secondly, the use of the upstream land or the higher land needs to be unreasonable. And thirdly, it needs to unreasonably interfere with the downstream or the lower lying person's use and enjoyment of their land. So there's a couple of things that you need to establish there to be successful in a case to establish nuisance. Let's talk about a couple of historic decisions, and most of the things that I've been saying or the principles that we are talking about have been drawn from these cases. The first of those is a very well-known decision called Gartner and Kidman. It's a 1962 High Court decision. Two farmers having an argument took it all the way to the High Court. I guess when farmers fight over land, they really do have a go, and this went all the way to the High Court. Gartner and Kidman is a fascinating decision. Mr. Kidman, I think, had concentrated water and directed it into an artificial watercourse and then pushed that down into Mr. Gartner's land where there was a sand pit and a bit of a sinkhole, and the water flowed off Mr. Kidman's land, draining a swamp and making more arable land available into Mr. Gartner's land and down into the sand pit and away. Mr. Gartner took objection to that and put up some barriers to pen back the water on Mr. Kidman's land, and the argument ensued. The High Court, I think it was Justice Windeyer, gave the leading decision and confirmed in Australian law the principle that a natural watercourse was not actionable, but as soon as you create an artificial watercourse, then you're not allowed to discharge that into your neighbour's land. And in this case, Mr. Gartner was within his rights to hold that water back off his land. Mr. Gartner, interestingly, had found out that there was money in sand pits and money in sand mining, and wanted to mine the sand pit, and I guess after this decision went on to do that and make some money mining the sand pit that was otherwise covered by the water from Mr. Kidman's land. All right, so that's Gartner and Kidman. The next case that I'd like to talk about is Melaleuca Estates and Port Stephens Council. That's a 2006 New South Wales Court of Appeal decision, and this is another great case to read if you're having trouble sleeping. In this case, Port Stephens Council had approved a number of developments upstream on some higher land, and as part of that approval, had carried out some stormwater infrastructure works and put a couple of pipes in and piped the stormwater discharge into Melaleuca Estates land, and from there out to the bay, but it caused flooding of Melaleuca Estates land. Now, at the time, the land wasn't owned by Melaleuca Estates. It was owned by the former owner, who was an elderly lady, and the council told her at the time, don't worry about it, she'll be right, we'll just put this stormwater infrastructure in, and then later we'll deal with it, and we'll put a whole bunch of filtration basins and other things in there so that we're not polluting your land. And that ultimately never occurred. Melaleuca Estates bought the land and brought the action against the council. And again, in Melaleuca Estates and Port Stephens Council, the Court of Appeal were scathing in their assessment of the council's actions. They found that the council should have carried out the works in the filtration basin to alleviate the impact on Melaleuca Estates land, and also that the council in this instance wasn't able to rely on the statutory defences in the Local Government Act that protects most local councils against prosecutions or cases of nuisance of this nature. And the council were ordered to clean it up and to fix and to cease and desist the discharge into Melaleuca Estates land. So that's Melaleuca Estates and Port Stephens Council. The next case is reasonably similar that I'd like to talk about. It's Gales Holdings and Tweed Shire Council. That's a 2013 New South Wales Court of Appeal decision. Similar circumstances. In this case, the Tweed Shire Council had approved and carried out a number of developments upstream, subdivisions and things. They had channelled and discharged stormwater across Gales Holdings land and from there out into the Tweed River, I think. But the artificial discharge and change in or alteration in the way that the water moved across Gales Holdings land resulted in ponding and pooling and flooding on Gales Holdings land. Gales Holdings complained and the council said, oh, well, too bad. One of the other interesting things about Gales Holdings and Tweed Shire Council is that by virtue of the ponding on Gales Holdings land, a protected species of frog took up residence in the area. I think it was the Wallam froglet, which is a threatened species or maybe even an endangered species. And Gales Holdings went off to council seeking development consent to subdivide the land. And council said one of the reasons for refusal was that the Wallam froglet was present on the land. Gale said, well, hang on a minute, that's not very fair. The frog wouldn't be there if you weren't discharging unlawfully into our land, and off to the Court of Appeal we go. Again, similar to Melaleuca Estates, the Court of Appeal held that the council were liable in nuisance for the negligent discharge of water into Gales Holdings land, and were found to be responsible for that and were ordered to address that. And again, these statutory defences were not available to the council in that instance. All right, so that's some interesting Court of Appeal and High Court case law on stormwater and the discharge of water across land. I'm going to just recap now with some of the general principles that I've discussed. The first one of those is that natural surface runoff is generally not actionable. The second one is that watercourses, the upstream owner has a right to allow the water to run through a natural watercourse into the downstream land, and vice versa, the owner of the downstream land has an obligation to accept that water and a right to have that water run through their land. And the third general principle is that whilst natural surface runoff is not actionable, as soon as you start to capture and concentrate and discharge that stormwater in some way, then you need to do that in a responsible way, and you can't do it in a way that materially and unreasonably interferes with your neighbour's use and enjoyment of their land. Okay, so hopefully that's been helpful and somewhat interesting. If you found that helpful, please don't forget to hit the like and subscribe button. That really helps us. And there is a very comprehensive and detailed article on this topic at our website at www.whiteacre.com.au. I highly encourage you to check that out if you are interested in this topic. Okay, thanks for watching.